That occurred outside City Hall and involved a large and decorated semi-truck that was incessantly sounding its horn in violation of the injunction order. That driver was arrested and the truck was towed from the highway.
Attention to me! What are you guys doing? Why are you creating violence? Do your job! You took an oath!
It's our position that the court was not made aware of any of the other arguments, especially, the constitutional and charter arguments that we take the position are supreme and override any bylaw considerations.
Adam Soos here for Rebel News. Spurred by a Twitter temper tantrum from Calgary Mayor Jyoti Gondek, the City of Calgary obtained an emergency injunction against those protesting against COVID-19 mandates. This injunction specifically prevented walking through the streets, blocking pedestrian access to amenities, and blocking sidewalks, in addition to a number of restrictions on amplification technology, some noise-making devices, as well as horn honking in the city. We have seen the troubling selective enforcement of this injunction against anti-mandate groups, while other groups enter the exact same areas and violate the injunctions in the same way and face no enforcement, signaling that this is in no way in the interest of public good. This is in fact simply targeted enforcement and silencing against a group of people who the political class simply doesn't agree with. This is exactly the type of affront against civil liberties that the Democracy Fund was started to fight against, and they're doing exactly that. You can actually make a donation at protestlawsuit.com to help fund the legal challenge against this charter trampling injunction. In a moment, I'm going to be joined by Chad Williamson of Williamson Law, who is going to break down the efforts in court, the legal efforts, to stand up against this injunction.
So the injunction is what we call a temporary injunction, which means that it should have a finite, length of time, in which it's in place and in force. Currently it's not. It looks permanent, even though there has been no hearing for a permanent injunction. It's my understanding that one has been scheduled for the start of May, but we've gotten very little information from the council, from the City of Calgary, upon which to kind of, base a response to this. What's the most troubling about the injunction itself is that it's tremendously overbroad. It's the interpretation of some that it could even apply to kids occupying a street playing street hockey. That's how overbroad it is. Now, is it ever going to be used to enforce, against kids playing street hockey? Probably not. But the way that it's drafted is such that law enforcement could take a sweeping, overarching interpretation of the provisions, and people could potentially get in trouble for actions that are not just common, but especially when we look at protests, are constitutionally protected. So the injunction prevents people protesting in parks, selling hot dogs in parks. There's a whole number of things that it prohibits that are lawful and constitutionally protected behavior. Maybe not selling hot dogs, but protesting certainly. So.
And I know there's some other metrics with like amplification and sort of very narrow and restrictive things. It's so interesting that you mentioned just how sort of broad and overreaching, or maybe not overreaching, but broadly reaching can be. It seems very much as though potentially it was structured so that it could be selectively applied. I'm not putting those words in your mouth, but we have seen that other groups, other individuals are violating the rules very overtly, without consequences in the exact same locations, but it seems to be only this group that was targeted out by Mayor Jyoti Gondek. It seems to be the only group that there's application of this injunction being executed.
Yeah, and that's fair. And that's one of the biggest issues, is just the selective nature in which enforcement of this overly broad injunction is being implemented. And what's so concerning is that it's super, super broad, yet they're very, very precise and selective about who they want the injunction to apply to. And one of the people that was caught up is one of our respondents, one of the John Does, is a local pastor who actually had nothing to do with the protests. And that shows you how overbroad, arbitrary, and how ridiculous it is that, quite frankly, anybody could be caught up in this thing, and the cops could just bust out a copy of the injunction and grab a pastor who was just preaching. And again, completely separate and apart from any of the freedom protests.
That's good news.
You're passing the con.
Okay, Brad, shame on you.
Oh my.
It's called freedom.
As we mentioned, thanks to our donations from people out there who are watching at protestlawsuit.com, you are launching this challenge, filing an application against this injunction. Is that correct? And what is the basis of that challenge?
So I've already enumerated a couple of our main points, but again, one, there was not an opportunity for anyone to respond because it was done ex parte. It's our position that the court was not made aware of any of the other arguments, especially the constitutional and charter arguments that we take the position are supreme and override any bylaw considerations. It gets fairly complex, and there are a number other legal positions that we're taking. But I mean, I think that's just the crux of it, is that it's overbroad. There's no time limit for when this thing ends. It was given without the other side of the argument being put before the court. That infringes the principles of fundamental and natural justice. And we've seen a concerning pattern of this happening and echoing throughout the courts over the last 2.5 years, and a challenge needs to be brought. Now, this is going to be a difficult application to bring, because it's very similar to some of the other challenges that we've brought. We're essentially going back to the same court to ask them to either set aside their judgment or to vary the judgment and vary the terms of this order. We may get that. There might be an option to appeal if we're shot down in that respect, but we're certainly going to ask that this matter be heard in its entirety from the start. We want the chance to cross-examine the people that swore affidavits in support of this, and frankly, it's our position that those affidavits are pretty skint. We don't know if the court really had all of the facts and the evidence put before it when it made this decision, and it's likely that it didn't. We want to be able to take up the banner and take up the position of the respondents and put a proper and thorough challenge both to the position of the City of Calgary and to test the evidence upon which the court relied to bring about this order.
Chad Williamson of Williamson Law, I want to thank you so much for this update. You're certainly the right man to be taking this on. For folks out there, if you want to help out with this legal challenge against this injunction that has fundamentally stripped Canadians, Calgarians particularly, of their rights, you can do so by going to protestlawsuit.com. Your contributions there are tax receipt eligible. They go to the Democracy Fund, so you're not only helping in this fight for freedom, but you'll receive a tax receipt for your donation. I want to thank you all so much for tuning in. For Rebel News, I'm Adam Soos. If you want to make a contribution to this legal challenge against this problematic injunction, you can do so by going to protestlawsuit.com. As I mentioned, any donation that you make is tax receipt eligible because those funds go to the registered charity, the Democracy Fund. So you'll be receiving a tax receipt for your contribution to the fight for freedom.